All right. This is the case of the State of Peter Jones v. Dragon Studios. Are both parties present ready to proceed?
Plaintiff's here, Your Honor.
As the defense, Your Honor.
All right. Let's hear appearances for the record.
Yes, Your Honor. Good afternoon. My name is Sam Farnsworth, and I'm here with Ethan Donovan.
Good afternoon, Your Honor.
And for the defense.
Good afternoon, Your Honor. My name is Audrey Vanderslice, and I'm joined today by my co-counsel, Ms. Jessica Alexander.
Good afternoon, Your Honor.
Today we represent the defendant in today's case, Dragon Studios.
All right. Before we proceed to opening statement, is there anything that we have to discuss?
Yes, Your Honor. Before trial, Your Honor scheduled a pretrial hearing on some pieces of evidence. Should we take that up now?
Before we get to the motion, are there any preliminary matters or housekeeping issues or things like that before we get to the substantive stuff?
Yes, Your Honor.
All right.
First, do we have your permission to move freely about the well during statements and examinations?
So the answer is, to the extent that you're going to approach the bench and adverse witness of the jury, please ask permission. You don't need permission to approach your own witness. With respect to moving around the courtroom, I'm going to give you pretty wide latitude. Just obviously use your judgment, but pretty wide latitude for me. Does that make sense?
Yes, Your Honor.
All right. What else?
We also moved to invoke Rules 603 and 615, calling for the constructive swearing in and sequestration of all witnesses.
Okay. All witnesses are going to be considered sworn. With respect to sequestration, do you have a position on that?
Yes, Your Honor. We just asked that sequestration be excluding party representatives today. We have a party representative in court with us today, and that will be Ms. Coldoy.
All right. Do you have an issue with that?
Not at all.
Okay. Then all witnesses are going to be constructively sequestered with the exception of Ms. Doig. What else?
That's all, Your Honor.
Okay. Ms. Vanderslice.
Your Honor, we just want to draw your attention to one pretrial order, which is that any witnesses that aren't testifying in today's case are considered not available under the federal rules of evidence.
Understood. Okay. Anything else?
That's all, Your Honor.
All right. This is your motion?
Yes, Your Honor. And before we get to that, because it pertains to the motion, we'd also just like to flag that opposing counsel has elected to use verdict form C for this trial, which means that the assumption of risk defense was dismissed.
Okay, so just to put this on the record, verdict form C, are you admitting liability?
Your Honor, today we'll be denying liability, and we'll also be raising an affirmative defense of comparative fault today.
Okay, so just for the record, we have the defendant denying liability and in the alternative pursuing a defense of comparative negligence and dismissing the defense that you raised previously in your pleadings of assumption of the risk, correct?
That's correct, Your Honor.
All right. What else?
We can get to the oral argument if Your Honor's ready.
Okay, so I understand that we've got a motion from plaintiff and a motion from defendant. Is that
That's
correct?
correct.
Yes, Your Honor.
I'll hear the motion from plaintiff first.
Okay, before we begin, it's our understanding we have 2 minutes for oral argument. If it's okay with Your Honor, could we use 30 seconds to raise our initial objection and reserve 90 seconds to respond to opposing counsel?
You can use your time however you want.
Yes, Your Honor. First, we object to Exhibit 36 under Rule 403 that it both confuses the issues and is misleading. If I could direct your attention to Exhibit 36, you'll see that the title is His Risks and He Chooses to Accept Them. He also ends by saying that Travis Harper can accept the risks of his mission, I can accept the risks too. As Your Honor knows, the assumption of risk defense was dismissed, so for this to be admissible, it confuses the issues for the jury and it should be excluded.
So,
Yes, Your Honor.
so I want to make sure that I understand. You're moving only under Rule 403 grounds, correct?
Yes, Your Honor.
All right. And so your written submission included grounds of relevance and hearsay. You're not advancing those arguments today, correct?
No, Your Honor.
All right. Is there a specific portion of Exhibit 36 that you are seeking to exclude, or is it really the document in its entirety?
Your Honor, we are moving to exclude the document in its entirety based on two reasons. The first are based on specific passages, but the second is that the risks detailed in this document are misleading for this trial specifically. There's actually a photo of the halo jump mentioned in Exhibit 36, and there's a second person involved in the stunt. That means that the safety precautions outlined for the All Loss Movie 6 were completely different than the safety precautions for this case. For opposing counsel to use this document to talk about the risks involved today, that misleads the jury.
Okay, and I'm not going to hold you strictly to the 2 minutes, don't tell anyone. But with respect, you said there was a specific portion of the document that you think makes the document in its entirety inadmissible. And I understand that you're saying it's different than the jump that's at issue in this case, but with respect to the lines in this exhibit, what specifically are you pointing to for that argument?
Yes, Your Honor. The title, His Risks and He Chooses to Accept Them, as well as the last portion, honestly, I love the thrill, I love pushing limits, I love exceeding limits, I never want to get bored. Hey, if Travis Harper can accept the risks of his mission, I can accept the risks too.
All right, Ms. Vanderslice, your position on that?
Yes, Your Honor. We'll take those one by one, as we believe opposing counsel is raising 2 separate issues. One is that it's misleading with regards to the charge we're pursuing today, and the second being that there are different risks in this stunt than what we're talking about. So starting with the verb. Now, we're actually happy to redact that one part about he chooses to accept the risks. We're not using this to show that he assumed the risk. We're pursuing a different charge today. That's fine with us. We're also happy to redact that if Travis Harper can accept the risks, then I can accept the risks too. That's fine with us. However, Your Honor, we do believe that that one line, honestly, I love the thrill, I love pushing limits, I love exceeding limits, I never want to get bored, in response to why he's not using stunt double, why he's doing these stunts himself, Your Honor, that actually speaks to exactly why there's probative value to this particular exhibit, and it doesn't substantially outweigh the prejudicial value. See, part of our burden today is going to be to show you that, in fact, he actually decided to do these stunts himself, decided not to use a stunt double, and we want to show you why that is. And it was because of the fact that he loved the thrill, he liked pushing limits, and that was the same in this particular case.
Okay, so I meant to ask you this earlier as well, but there was also a 404 argument that was advanced in your written submission. Are you abandoning that argument now?
Not based on opposing counsel's proffer, Your Honor. If they're using this to prove that he loved risks in the past, to prove that he loved risks again in the future, that's inadmissible character evidence.
Yeah, why is this not propensity evidence?
Yes, Your Honor. The reason it's not propensity evidence is we're not using this prior instance to show that because he did something so dangerous then, he was willing to do something so dangerous now. In fact, if I may proffer, Your Honor, we don't believe anyone's going to contend in this case that this wasn't his idea. We all agree he came up with the stunt himself. The reason the reason we're using this evidence, Your Honor, is actually under 404B. It's a permitted use to show that he actually had a motive to want to be doing these stunts in this case. There was a reason why he wanted to do it, and that was to wow his audience. He had a reputation to maintain, and so he actually intended to go up there and do something dangerous, not propensity.
Except, how do you respond to this? The lines that counsel's objecting to don't say, I love the fact that my fans think I'm a risk taker. They say, I love the thrill, I love pushing limits, I love exceeding limits, I never want to get bored. How do you tie that to your motive argument that because he had this reputation within the entertainment industry, he wanted to maintain it? How does this exhibit advance that argument?
Your Honor, we believe that this actually goes towards his mindset when doing it, and it was right after he said, why do you do it? To make the movie magic, to wow the audience. He says, but did it have to be you? Why was he doing it actually himself? And it was because he loves to do it, and that was actually his mindset about these kinds of stunts. That's why he actually intentionally wanted to do it this time. It goes to his motive in choosing to do these stunts.
Yeah, one more question on your rule. How do you intend to offer this exhibit?
Exhibit 36.
Correct.
We do not intend to offer it, Your Honor.
Well, good point. How do you intend to offer this exhibit?
Yes, Your Honor. The only reason we hope to use this exhibit is to show that he actually had a motive to be doing the stunt that day, that he wanted to wow the audience, and that was the purpose of this particular. He actually had an intent to himself be exceeding those limits. We're happy with the limiting instruction of the jury. We intend to use this for no propensity purposes, that he was such a risk taker. That's not.
Yeah, my question was bad. Is there a witness that you intend to use this with? How do you intend to admit this?
Yes, Your Honor. We'd actually like to use this on the cross-examination of the agent.
Okay.
Just to show that their client, was actually had a motive and intended to do these dangerous things.
All right, so here's what I'm going to do. I'm going to deny the motion on the bases, based on the arguments are both well taken, and certainly something you can pursue on examination of the witnesses and submit argument based on this exhibit to the jury. However, I am going to deny the motion without prejudice. You can re-raise it to the extent that you think the way the exhibit's being used or the witness through which it's being offered makes the evidence impermissible for some other reason. So I'm denying the motion for now, but I am going to give you leave to re-raise the arguments to the extent that you think there's a problem. Does that make sense?
Yes, Your Honor.
What's next?
Your Honor, we actually raised our own motion to exclude a different exhibit, Exhibit 37.
Okay.
May I proceed, Your Honor?
Yes.
Your Honor, we raised two issues with Exhibit 37. The first is that it should be excluded under 404B, and the second is that it should be excluded under 801 D2D. Would you all like me to take those one by one?
Do you have an extra copy of that? I have an electronic copy, but easier.
I believe we do, yes, Your Honor. Permission to approach?
Yes, please. And I'll give it back. All right. So you said you've got two arguments. I'll hear the first one.
Yes, Your Honor. Pursuant to 404B, it's inadmissible to use previous instances to prove action in conformity therewith. Now, that's exactly what this document is doing. Now, permission to give you a little context about what this document is saying.
Please do.
This document is an interview of Cole Doy, the producer in this movie, but it's about a different movie. It's about a different set, different actors taken 12 years ago. That's exactly, therefore, what this particular exhibit is being used for, then action in conformity therewith. It holds no probative value about this actor, about this set, about this movie, so it's only being used to show that there is action in conformity therewith.
Okay. And I'll let you respond to that argument first, then we'll take the second one.
Yes, Your Honor. This document discusses the defendant's willingness to lie to their actors in order to get the best out of them. We're using this under Rule 608, that it goes to a witness's truthfulness, which means it's permitted character evidence. And we're also going to be using this on cross-examination of the defendant, which makes it admissible even though it's a specific instance of conduct.
Okay, so let's pause there. What is your response to, and with respect to Rule 608, you're saying that you intend to cross-examine Ms. Doy regarding that statement, correct?
Correct.
All right. What is your response to Mr. Farnsworth's argument that the prior instance where he says he would lie to an actor to get a better scene is permissible under Rule 608?
Your Honor, we actually believe there are multiple instances that are being referenced in this particular exhibit, and a lot of them have nothing to do with truthfulness. A big part of this particular exhibit is that there was actually a stunt that this director made riskier on this different set. They're using that to show that, well, in this case, he was willing to take these risks, and then that he was willing to take these risks, Your Honor, and to prove that he would actually do that again in this case. So that proportion of this exhibit, we'd ask to be redacted.
Okay, so let me pause there. Are you willing to agree that that evidence with respect to making other stunts riskier, et cetera, is out, and your argument only relates to the evidence with respect to the lie? Is that what we're talking about? Do we have an agreement on that or no?
No, Your Honor, because the lies don't make sense without the added risk that the defendant concealed.
Okay.
No, we actually disagree with that. They can say whether or not she was actually truthful with her actors without having to go into the details of the fact that she was making these riskier. And that's the particular character trait that makes this inadmissible character evidence.
Okay, like the last one, I think this is well argued. I'm going to deny the motion. I'm going to allow the evidence in to impeach the witness's character for truthfulness. However, to the extent that you believe that counsel is using the exhibit to demonstrate a character trait not admissible under Rule 608, in other words, something separate from truthfulness, then I'm going to also give you leave to raise your objection then.
Yes, Your Honor.
All that said, I still want to hear your argument with respect to I think it was a hearsay.
Yes, Your Honor.
basis.
It was an objection under 801 D2D. You see, these actual statements, they are being made by a party opponent's employee, but they're not being made in the scope of the employment. You see, this particular interview, it doesn't mention Dragon Studios anywhere. It doesn't mention the franchise that we're talking about today anywhere. It doesn't mention the actor involved in this anywhere. It was not made in the scope of the employment. This interview was of the individual. You'll see the individual's name is in the subtitle, and that's the only scope of this particular interview.
Why are these statements made to Hollywood Today within the scope of employment?
Yes, Your Honor. Because he begins the interview by saying, or pardon me, the interviewer says, I sat down with executive producer Cole Doig to talk about the film. The context of the interview clearly shows that Mr. Doig was, or Ms. Doig was there because she wasn't an executive producer that owned Dragon Studios. That's why it shows that this was in the context of her.
Okay, I have one question for both of you, and then I'm going to rule. Ms. Vanderslice, my question for you is, wouldn't you agree that an executive producer giving an interview to a Hollywood publication about the opening of a movie is certainly within a producer's, the scope of their employment?
No, it's within the scope of an employment, but there's actually no foundation that she was actually employed by Dragon Studios at the time this document was made. That's not on the record, and this interview was done in 2012.
Let me interrupt you. Are you going to dispute that? That she was employed in 2012 by the studio?
Your Honor, there's just no foundation right now within this particular exhibit.
Okay. And then my question for you, Mr. Farnsworth, with respect to the hearsay argument is, aren't these statements made by the author of the article relaying Ms. Doig's statements?
Yes, Your Honor, but they're adopted statements. The defendant agreed with all of the statements contained within this interview in their deposition, and you're allowed to rely on that deposition.
That's what I thought you might say, so just to make sure I understand, your argument is the witness is going to concede that she said these things.
Exactly.
Okay. Again, close call. For all the reasons that I said, I'm going to allow you to re-raise the objection to the extent that you think something's being done that's outside the bounds of what was represented by counsel. But I think I'm going to allow this in for now without prejudice to re-raise. Does that make sense?
Yes, Your Honor.
All right. You ready to open?
Yes, Your Honor.
And I promise you have that back.
Thank you, Your Honor.
May I proceed?
Yes.
He waited for a signal that never came. It's June 21st, 2023. Movie star Peter Jones is getting ready for a big stunt. He straps on his parachute, steps into his motorcycle, and puts in his earpiece. He's nervous, but he's got a team behind him. He trusts that team to signal when it's time to deploy his parachute. He hits the throttle, rushes down the ramp, and flies 2,700 feet up in the air. He begins to fall. 2,500, no signal. 2,000, no signal. 1,500 feet, no signal. 1,000 feet, no signal. 500 feet, no signal. And by this point, he pulls the cord on his parachute, but it's too late. Peter Jones hits the ground too hard, and he dies. He waited for a signal that never came. And that's why we brought an action of negligence against Dragon Studios, the production company that was responsible for his safety. Now, as the plaintiff, we bear a burden of proof. We have to show you it's more likely than not that the defendant failed to exercise ordinary care, and that failure caused Mr. Jones' death. We're going to meet our burden using 3 very simple facts. First, the defendant promised Mr. Jones to signal when to deploy his parachute. The defendant never sent that signal, and because of that, Mr. Jones died. Let's walk through exactly what that means today. First, the defendant promised to signal Mr. Jones to deploy his parachute. Today you're going to hear that this stunt was coordinated by Dragon Studios. And part of this stunt involved an earpiece Peter Jones would wear in order to know when it was time to pull his sheet. You're going to learn the defendant promised the night before Mr. Jones died to send a signal after 9 seconds had elapsed of free fall. That's what they promised. But that brings us to fact 2. The defendant never sent that signal. Today, we're going to call someone named Eli Goia. He was Mr. Jones' agent. He was actually in the control room the day Mr. Jones died, the place where the signal was supposed to be sent from. He's going to tell you he watched. As Miss Cole Doy watched the defendant fall. And that she waited and waited and waited until it was too late. He's going to tell you he never heard her signal once. And you're going to learn why she didn't speak. Today you're going to learn that the defendant was willing to lie to their actors in order to get the best out of their scenes. And that they wanted an action scene for the agents. You're going to hear that the longer Peter Jones spent falling, the better the defendant believed the shot would look. That brings us to fact number 3. That because the defendant failed to signal Peter Jones died, you're going to learn there were other ways, other than an earpiece, for Peter Jones to know when to deploy his parachute. Devices like an altimeter. But you're going to learn the defendant once again told Mr. Jones not to wear an altimeter because it would ruin the shot. And because Mr. Jones didn't have that protection, because he relied on the defendant's trust, you're going to learn when she didn't send that signal, he didn't know when to deploy the sheet. Members of the jury, some cases are complicated, but this case is actually pretty simple. The defendant wanted a longer cut, and that's what cut Peter Jones' life short. That's why at the end of this trial, I'm going to ask you to find the defendant lying. Because Peter Jones waited for a signal that never came. Thank you.
Thank you, counsel.
Opening from the defense.
Whenever you're ready.
May it please the court. Mr. Farnsworth, members of the jury. It was his life on the line. He made the call. When you think of a movie set, you think of a director with a vision, you think of a producer who's there to make it all happen. And when you do, well, you think for some actors, those people call the shots. But today you're going to learn that this case isn't about just any actor. It's about Peter Jones. You've probably heard of him. And unlike other actors, he wants to wow his audience. So he doesn't use stunt doubles. He doesn't use special effects. No, every stunt, every scene, it's his life on the line. And everyone who's ever worked with him knows that on his sets, Mr. Jones makes the calls. So let's step up to Mr. Jones' set for a moment. They finish shooting the final scene. The movie's wrapping up. But the director pulls him aside and says that they're going to have to use special effects, video editing, to make sure that the biggest stunt of his career can happen, can be as long as they need it for the movie. So Mr. Jones makes the call. He says, no, we don't need editing. I'll just hold on for longer. I'll just pull my parachute later. So the next day he shows up to work and he does that. He sets up his bike. And he goes off of that cliff and he goes into free fall down the side of the mountain. 5 seconds. 7 seconds. 9 seconds. And contrary to what you heard just now, his producer's in his ear yelling, pull! Pull your parachute, pull! But it's his call to make. 10 seconds. 11 seconds. 12 seconds. It's his life on the line, but he doesn't pull. 13 seconds. And guys, there's the jury. What was Dragon Studios supposed to do in that moment? Sure, it's their movie. But it's his stunt, his plan, his choice, his life on the line. It's his call to make. And when the plaintiff takes on a burden, when they choose to say that it was their fault, Dragon Studios, well, I can't just tell you that. They have to prove it. They have to prove it's more likely than not that they actually made careless decisions. And that those careless decisions are what caused Mr. Jones's harm. Today you'll hear they're not going to be able to meet that burden for 2 reasons. The first is that Dragon Studios was careful. You're actually going to meet that producer they told you so much about. And she's going to take the stand and she's going to tell you that they shelled out millions of dollars to make sure that every stunt that was run on that set was as safe as it could be. That they built a practice ramp, that they actually had contingency plans in place. But at the end of the day, Mr. Jones was the one making the calls. And that brings us to our second point. You see, it wasn't the production company that decided that Mr. Jones had to go up in the air a 7th time. No, that was Mr. Jones's call. And you see, that was his call to make. His contract wasn't conditional on it. You'll hear today that it wasn't required. Mr. Jones just decided he'd rather do that than use the special effects they offered, than use the stunt double they offered, than use the safety harness they offered. And we expect that no one, not Mr. Farnsworth, not a witness, not Mr. Jones's agent, no one who takes that stand will be able to deny that on that set, Mr. Jones made the calls. Mr. Jones called the shots. And that's why we've brought something called an affirmative defense today. And what that means is we brought an affirmative defense for something called comparative negligence. Now the judge is going to explain that that doesn't mean we're here to blame Mr. Jones or to judge Mr. Jones. It just means you get to consider whether it's more likely than not that Mr. Jones's decisions weren't careful and that those decisions might have caused his death. And we're going to meet that burden today because you're going to hear that from the beginning, he refused the stunt double, he refused the safety harness, he refused the safety measures. Members of the jury, I want to be clear. You only need to consider our burden if you think that the plaintiff has met theirs, and they're not going to be able to do that today because as much as I wish I could tell you, at the end of today's trial, you'll know who's right and who's wrong about who called the signal, that you'll know exactly what happened up in the air that day. The plaintiff won't be able to prove it to you. But what you will know is that Mr. Jones called the shots. So at the end of today's trial, I'm going to ask that you find Dragon Studios not liable. Thank you.
Thank you, counsel. Plaintiff, call your first witness.
Plaintiff calls Eli Goia. Do you need that help, sir?
I'll be good, thank you. Younger than I look.
Are you set?
All good.
May I proceed?
Please do.
Good afternoon, sir. Please introduce yourself to the members of the jury.
Good afternoon. My name is Eli Goia.
So what do you do for a living?
I'm an agent for actors. I make sure we get movies signed up. I work with them.
How'd you get into that?
Well, I always wanted to be an actor myself. And out of 755 auditions, I got one thing. A foot cream commercial. After that, I decided it's not for me.
All right, sir. While you were an agent, did you ever represent somebody named Peter Jones?
No, I did. We did a lot of movies together. He was a good friend of mine.
Were you representing him when he died?
No, I was. It was for an all-lost movie, the 7th installment.
What company was producing that movie?
It was Dragon Studios. We had worked with them before in the past as well.
Sir, do you know who Dragon Studios' producer is?
I do. It's Miss Coldog.
You see her report?
Yes, sir.
Could you identify her with an article of clothing?
She's sitting right over there with the black blazer against the wall.
The witness has accurately identified the defendant.
Okay.
Sir, when did Mr. Jones die?
June 21st, 2023.
How did he pass?
We were doing a stunt. It's something we'd never done before. It was with a motorcycle. He drive the motorcycle off a ramp, let go of the bike, pull a parachute and land on the ground.
Okay, I want to walk through exactly what this stunt entailed, sir. How long was Mr. Jones originally supposed to be free falling after the jump?
After he left the ramp, only 4 seconds. That was the plan. After 4 seconds, he'd get a call. Someone would tell him to pull it, and he was supposed to pull his shoe.
How was he supposed to get that call?
It was from an earbud. We made sure he had an earbud out there with him, and Miss Doyle was to give him the call.
Would you recognize that earbud if I showed it to you?
I would.
I'm approaching the witness with Exhibit 5. There it is. You recognize that?
No, I do. This is the earbud he had.
Sir, who was supposed to signal to Mr. Jones when it was time to deploy his parachute?
That would be Miss Doyle. That was her job that day.
Okay. If that's what was supposed to happen, let's talk about what happened on June 20th, 2023. Where were you?
On the 20th, I was in the control room. I was with Miss Doyle and some other crew members.
How the stunt began?
We started on the ramp. He takes the bike and he goes off of it.
Did Miss Goia, did she signal Mr. Jones during that stunt?
On that day, she did. After 4 seconds, she gave him the call.
What did Mr. Jones do?
Your Honor, lack of foundation, specifically as to how this witness knows how many seconds had gone by. We just need a little bit more foundation on the record as to this witness's personal knowledge about the clock and how they were timing that on the day of.
Yes, Your Honor. This witness was in the room. He said that 4 seconds had elapsed before Ms. Goia gave the signal. That's all the foundation that's needed.
What's the issue then?
Yes, Your Honor. In this case, seconds matter, quite literally, and we're not sure exactly how this witness has the foundation to know exactly how many seconds had gone by. Whether he's looking at the same monitors they were, whether he was using the same timepiece to do so. We just need that foundation on the record as to how this witness has that knowledge.
Okay, I'm going to overrule the objection. I think that's something you can probe on cross, but I think it's permissible under 701 for him to say that 4 seconds had passed.
Yes, Your Honor.
It's overruled.
Sir, on June 20th, when Ms. Goia gave the signal, what did Mr. Jones do?
On that day, I can see it through the screen. She gives the call. He pulled the chute. He landed safe. It was amazing.
Did you do the stunt again?
We did. We did it again. It went just fine. She gave him the call. Chute went off. We did it 6 times that day. Every single time. It was better than the last.
Did did you get a take after those 6 different shots?
We did. Filmed every single one.
Then let's talk about why you were filming on June 21st. Sir, did you talk with Ms. Doig and Mr. Jones that evening?
Yes. We had a conversation. Miss Doig, she said that she wanted to change it. Wanted a longer scene.
Did you say why?
She said she thought the ones we took were too short. Just wanted something bigger and better. Wanted 9 seconds this time.
What did Mr. Jones say?
At first he looked a little hesitant. He asked whether or not someone else had signed off on it.
What did Ms. Doig say at this point, sir?
She said the stunt coordinator that we had gave the okay. Said it would be okay to do that stunt.
Okay, I want to slow down here and make sure something's clear. During this conversation, did Ms. Doig ever say she wouldn't signal Mr. Jones?
No. She said she was going to be the one to give him the call at 9 seconds.
Then let's talk about whether she kept that promise. Sir, on June 21st, 2023, during the stunt, where were you?
I was in the control room. Again, I was looking at the screen. It was just me and Miss Doig in there.
How'd the stunt start?
Started the same. Got on his bike. He rides off the ramp. He went into the air.
So what happened while he was airborne?
We were watching the clock. We waited for it to get to 9 seconds. And 9 seconds, Miss Doig, she never made the call.
So what did you do?
It hit 10 seconds, and I started yelling. You gotta tell him to pull it. He needs to pull it. Tell him he needs to pull his shoe. She just puts her hand up at me.
So did Ms. Doig ever make that statement?
No. At about 15 seconds, Peter just pulled it himself.
What happened after Mr. Jones pulled his parachute?
We thought maybe he had enough time. But we saw he hit the ground, coming in fast. We went to go check in on him.
So did you ask the defendant why she didn't signal?
And I did. We got down there, and I asked her. She looked me in my eyes and told me she thought she had enough time.
Thank you. No further questions.
Cross.
Yes, Your Honor.
Proceed.
May I proceed, Your Honor?
Yes.
Good afternoon, Mr. Goia. Thank you for coming in.
Of course.
So before I ask you any questions, I just want to say I'm so sorry that you lost your client that day. I'm going to ask you just a few questions to get you right out of here.
Yes, ma'am.
So I want to talk about whose idea it was to perform this stunt. Because 2 years ago, Dragon Studios didn't call you up and say, gosh, I have this great idea, did they?
No. It was Peter's idea to do the stunt.
That's right, they didn't call you up and say, how fun would it be to have your client drive a motorcycle off a cliff?
No. They didn't say anything like that.
That's right, Mr. Jones came to them with this idea.
Yes, ma'am.
Mr. Jones is the one who asked for this stunt to take place.
He did.
Well, I want to talk about why. Why Mr. Jones was doing those stunts. Now, you were his agent on all of the movies, right?
I was. We worked together for quite some time.
And part of your responsibilities as his agent was to be there when all these stunts were happening. You filmed.
Of course, I got to be on set. talk to directors, the whole spiel.
And you had a lot of conversations with Mr. Jones about those stunts, right?
We did. We would talk about the plan and coordination.
And he shared with you that when he was filming this movie, he felt a lot of pressure, right?
He did. This was something we hadn't done before.
You know that he loved his audience, right?
Peter did.
He wanted to make his audience happy.
Of course. It was always Peter's goal.
And you know that he'd set the bar pretty high for his audience, right?
Peter was a great actor, man, yes.
You'd recognize some photos taken from those previous stunts, right?
Yes, ma'am.
Now, with permission to approach opposing counsel in the witness in turn with copies of exhibits 26 through 29.
Yes.
Thank you.
Courtesy copy for the bench, Your Honor.
I have a copy, thank you.
Now, Mr. Goia, these are pictures from the stunts that he done on previous movies, right?
Yes.
These stunts, they all went into theaters, right?
They did.
These were the stunts that his audience had watched at AMC or their theaters.
That's right. This is him hanging from a cliff.
Objection, Your Honor. Before we show the exhibits to the jury, we do have an objection to their admissibility.
All right.
We completely agree, Your Honor. We're actually like to move to enter them into evidence at this point.
Okay, so we'll take that up now then. Are you objecting to all 4 exhibits?
Yes, Your Honor.
Okay.
Under Rule 404, opposing counsel is using these prior stunts to show that Mr. Jones had a habit of recklessness or risk-taking behavior, and that he did something similar on June 21st, 2023.
Response.
Your Honor, we are not using these exhibits to show that he was reckless. It's already on the record that he's the one who came up with the stunt we're talking about today. All we're using these for is to show that he has set a high bar for his audience, and this is probably what they'd come to expect. We're happy with the limiting instruction of the jury. We're just using it under 404B to show that he had a motive to actually be choosing dangerous stunts.
Well, hang on a second, just a few questions. One is that, isn't your argument that he was comparatively negligent for not pulling the cord when Ms. Deutsch said so?
Your Honor, actually our argument is that he made several decisions that made this stunt less safe to make the stunt more impressive for his audience. That might have included him not pulling the parachute.
Right, so would you agree then that there isn't sort of an element in your case where you're arguing that the thing that he did that day, on the day in question, was, I don't know that I would go as far as say reckless, but negligent at least?
Yes, Your Honor, we're arguing he's negligent. That's just not what we're using these particular exhibits for. All we're using these exhibits for is to show that he actually had a motive to be doing dangerous things in the first place, and that's why he did all those things. That's why he would have been negligent. We're not using these in particular to show that negligence.
What's the motive?
The motive, Your Honor, is that these particular exhibits, and as I was just questioning this witness, well, they show what his audiences were seeing in theaters. It shows the bar that he had set for the stunts that they had come to expect, and that's why, in this case, he had actually a motive to not use a stunt double, to not use CGI to do it himself.
What's your response to the argument that these photos demonstrate that this is an actor who was pushing the limits and setting the bar very high, and that was sort of the motive here to maybe set the bar a little too high?
Yes, Your Honor, I'll take that in 2 parts. The first is that opposing counsel already elicited that Peter Jones designed the stunt for this case. So for her to elicit testimony that he had a reason to do so, that doesn't have any probative value. These are clearly being used for the second part of what you just said, that Mr. Jones had a habit of pushing the limits of what was done. And that is not admissible under Rule 404. It's being used to show a character trait, and it therefore ought to be excluded.
Last word and then I'll be on rule.
Yes, Your Honor. We actually believe that the reason why he was doing this helps explain why he would have been negligent in the first place. His audience was coming to expect these really crazy stunts. We're not saying that in this case he pushed the limits, he made it out of these perfectly fine, but what we're using them to show is that he had a motive to go and impress his audiences beyond what they'd already seen, and that's why he was negligent. Mr. Farnsworth said it himself. It's already on the record that he made the decision to do this stunt in this case. This just helps explain why he had a motive on the day of.
Last question, and I promise I'm going to rule. How are you going to tie that up with this witness? Is this witness going to say that in having conversations with his client, he said, gosh, I've done all these crazy things in these other movies, I've really got to meet that bar here?
Actually, Your Honor, that's the foundation we laid before we even showed him these exhibits, that he had had these conversations with Mr. Jones, and that Mr. Jones felt the pressure to show his audience even more, and that he'd already set the bar high. We specifically laid that foundation to signal that we're not using these for the recklessness, just for that motive, to impress his audience.
Okay, so here's what I'm going to do. I'm going to allow them conditionally, to the extent that you think the photos are being used to show propensity, because I would agree with you that I don't think they can be used for that purpose, obviously. But to the extent that you think we cross the line into propensity evidence, and we're sort of outside the bounds of this motive or pressure argument that counsel's making, you can raise your objection, but for now, I think they're permissible for the limited purpose that you described. Does that make sense?
Yes.
Yes, Your Honor.
All right, let's proceed.
Mr. Goia, I just want to ask you a few questions about what his audience that had seen these movies might have come to expect. Now, we'll take these one by one. Exhibit 26. His audience had seen him hanging off a mountain.
Your Honor, is it all right if I can move to see the...
Sure, please.
His audience had seen him hanging off a mountain.
Yes. It looks like it's Tom Cruise, but that's Peter Jones, I swear.
In Exhibit 27, that's Mr. Jones. His audience had seen him hanging off the building.
Yes, that's right.
The tallest building in the world.
It was pretty tall, yeah.
In Exhibit 28, well, he's hanging off an airplane. That's what an audience had seen.
Okay, this one looks like Tom Cruise too, but I swear that's Peter Jones. He did all his own stuff.
That's right. Mr. Jones did all of his own stunts. That's what an audience had seen 6 times.
Yes, ma'am.
And did his audience see him hanging off of a plane that was still, or a plane that was moving?
It was moving all right.
And 29, here, his audience had seen him underwater, right?
Yes, ma'am.
And you were there when he was filming it?
I was there. I was on set.
Can you tell us how many minutes his audience had watched him stay underwater?
I believe like 6 minutes or something.
Objection, Your Honor. Do you believe that this line is getting into propensity evidence at this point?
How so?
Opposing counsel hasn't tied up the loop by suggesting in any way how this goes to Mr. Jones' mindset. All they're doing is reciting the risks that Mr. Jones took and he shot. That's clearly being used to show a pattern of behavior back then and in the case at hand on June 21st.
Response.
That was my last question about these exhibits. We're really just using them to show that his audience had seen him do all of these things, and we're actually going to bring in another exhibit, if I may proffer,
Okay.
to show why he was doing these stunts. We're really just using this for his mindset. We're not going to ask the jury to consider how risky these were. It's just about the audience.
Okay, I don't think we're quite outside the bounds of my ruling yet, so I'm going to overrule that for now, okay?
Yes, Your Honor.
Now, as you can see, Mr. Goia, well, he'd actually set a pretty high bar for his audience, right?
Yeah. We would do a lot of stunts, yes.
Now, you were present during an interview that your client did, right, on June 1st of 2023?
Yes, ma'am. That was before we shot the film.
That was just about 19 days before he passed.
It was.
Now, permission to approach opposing counsel and the witness in turn with what has been pre-marked as Exhibit 36.
Okay.
Our understanding is that these are not considered in evidence yet.
Not yet.
Sir, that's a transcript of that interview, right?
Yes, I believe so.
It's a fair and accurate copy?
Yes, ma'am.
Hasn't been changed or altered in any way?
No, I don't believe so.
Your Honor, at this time, we move to enter Exhibit 36 into evidence.
We object, Your Honor, under character evidence, and we'd also just flag that the redactions opposing counsel conceded to are made before this is in evidence.
Okay, so let's try to get this done quickly. So the redactions are the title of the article, correct?
Yes.
Anything else?
Yes, Your Honor. In the last answer, opposing counsel can test the first half of the answer, whether or not, but I believe that she agreed to redacting everything after, hey, if Travis Harper can accept the risks of his mission, I can accept the risks too.
Is that correct?
Our understanding of the redaction is that it's just the second half of the title that's being redacted, and he chooses to accept them. It's not what we're arguing today. We agree with that last line. We're redacting that.
Okay, so we're going to redact, hey, if Travis Harper can accept the risks of his mission, I can accept the risks too. And we're going to redact, and he chooses to accept them. The only thing we don't have an agreement on is his risks, correct?
Yes.
We also do not have an agreement on the rest of that last answer. We still contend it's character evidence, that it's clearly being used to show that he had a habit of pushing limits in the past and he did so in the future.
Okay, so I'm going to note your objection with the record. You've preserved that. And so do you have any additional argument beyond what we discussed pre-trial?
No, Your Honor, if it's preserved, we're good with that.
Okay, so again, I'm going to overrule your objection without prejudice. Let's proceed.
Yes, Your Honor. Mr. Goia, at the end of this interview, they're talking about the stunts that Mr. Jones was doing on set, right?
Yes.
And they asked about some of the calls that were being made on set about safety, right?
In the last part,
Yeah, they asked how much of the jump is special effects, right?
I believe so.
Mr. Jones says 0.
That's right.
The interviewer asks why do it, right?
They do.
And Mr. Jones says to make movie magic,
Yes.
to wow the audience.
Yes, ma'am.
Now, I'll take that back, each.
Of course.
I want to talk about who made the calls on set. Sir, you'd agree that the studio, they actually offered for Mr. Jones to use a stunt double, right?
We had talked about one, yes.
But Mr. Jones made the call not to.
Peter's never used a stunt double before. I think he was going to start using one anytime soon.
And you mentioned a conversation with you and Ms. Doig on direct examination. I want to break that conversation down because during that conversation, Ms. Doig actually gave Mr. Jones a choice, didn't she?
Yeah, but we had talked about whether or not we wanted to do it, yes.
She gave him 2 choices. One of the choices was that she could edit the scene to make it longer.
Objection, Your Honor, hearsay.
Response?
Your Honor, these are all questions that she asked, asking if they were willing to edit the scene or not.
Response, Your Honor.
Yes.
Yes, Your Honor. They're using this to show that there was, in fact, an option for this stunt not to happen. That's what's contained within the statement, that there was actually a choice to be made, and they're using it to assert that truth.
Do you contest that happened?
Yes, Your Honor. We contest what actually went on during that.
So is this witness going to testify that that conversation did happen?
Yes, Your Honor. He's going to testify about the circumstances surrounding that conversation, but the specific statements that were said, we are contesting. And we're also contesting the truthfulness of that statement, more importantly, that there was actually a choice to be made. It's our contention the producer pushed Mr. Jones into his decision.
Brief response, Your Honor. Regardless of whether it was a question or not, we're not even using that for the truth of the matter, sort of that they actually could successfully edit this footage the way they wanted to. We're using really for the effect on the listener, Mr. Jones, that he was given this option, these 2 options, and that in that case, well, Mr. Jones made the call. Opposing counsel's witness isn't going to contest that those choices were given. It's their own witness who's saying this conversation happened.
All right, I'm going to allow the statement from Ms. Doig in to show the effect that it had on Mr. Jones, specifically that after being presented with this choice, he decided to go forward. So let's proceed.
Yes, Your Honor.
Mr. Goia, I'll re-ask my question. Mr. Jones was given 2 choices in that conversation, right?
Yes, we talked about doing the stunt.
One of the choices that Ms. Doig offered was to edit the footage to make that scene longer.
Yes.
And the second was for him to redo the stunt, right?
That's right.
She even offered to lie if the media asked about it.
Yeah. She said that. Ms. Doig said she would consider lying.
She even asked if that would change Mr. Jones' mind.
Yes.
But it didn't. Mr. Jones decided to redo the stunt for a 7th time.
Yeah, after Ms. Doig said it was safe with the coordinator, Peter agreed.
He decided to do it without a safety harness,
Yes.
without landing pads.
Yes, we were doing the real stunt this time.
He made those calls.
We all did. We all talked about it.
Thank you. No further questions this time.
Redirect.
Your Honor, permission to just publish exhibits 26 through 29 and then exhibit 36 to the members of the jury?
Yes.
So you were just asked several questions about whose call it was the day of this stunt. I want to be clear. Did Mr. Jones ever make a call to forego receiving a signal during the stunt?
No. The plan was always for Miss Doig to give him the call.
You were also asked about a conversation between Ms. Doig and Mr. Jones. What did Ms. Doig say to get Mr. Jones to agree to the stunt?
she said she would consider lying. After that, Peter, he was thinking about it for quite some time.
Did you say anything about a stunt coordinator?
Yes. Ms. Doig said that the stunt coordinator said it was okay to do it. Gave the okay.
Thank you, sir. No further questions.
Okay.
No redirect based on that.
All right.
Or recross permissions.
We're okay with the witness being excused. May we publish Exhibit 5?
Yes. Do you have any other evidence to put on your arrest?
Yes, Your Honor.
Yes, to which one?
We do have more evidence to present. We're going to be reading lines from Sky Stebbins' deposition, the stunt coordinator in this case, on the record.
Okay. Have you disclosed the pages and lines to counsel?
No, Your Honor, I'll do that now.
Okay.
We're reading lines 164 to 171.
No objections, Your Honor.
All right.
May I proceed?
Yes.
Before you left, did you discuss the possibility of doing an additional take of the stunt? Yes. On June 20th, before the group dinner, Cole Doig pulled me aside. Doig asked if I thought we could do one more take of the motorcycle stunt on June 21st, except this time Doig would delay giving the signal until Peter had been in the air 9 seconds. Doig said, I used your numbers and worked it out. If I give the signal at 9 seconds, the parachute will be inflated by 13 seconds. Peter is still above 1,000 feet. That's still safe. How did you respond?
Objection, Your Honor. We believe the opposing counsel was going to start right before that line. Were you mistaken?
I believe I said until line 171.
That's what I thought too. Do you have an
Your
objection?
Honor, in that case, I do have an objection under Rule 702, specifically to the opinion statements that are going to be offered by Sky Stebbins.
Your objection to line 171?
To line, yes, Your Honor, to Sky Stebbins' opinions about it cutting too close, especially when she's not there.
What's your response to that?
Yes, Your Honor. We're using this for its fact value in this case. The witness just stated that during this conversation.
Hang on, for the record, you mean the witness that testified live?
Yes, Your Honor. The witness that just testified live said that the defendant told Mr. Jones the stunt coordinator had okayed the stunt. This shows exactly the opposite. The stunt coordinator says, no way, that's cutting it too close. That not only goes to the defendant's credibility, it also goes to her intention to lie to Mr. Jones to get him to agree with the stunt.
What's your response to that argument?
Yes, Your Honor. Part of opposing counsel's burden today is to show that there are actually decisions that were made that weren't in the ordinary care that a company should show. They're most certainly using this to show that there was an expert who said that it's cutting it too close, especially when she's not there. They're offering that expert opinion to show that it actually was cutting it too close.
What is your response? And then I'm going to roll because I don't want to belabor this. What is your response to his argument that rebuts the idea that the truth was disclosed to the decedent about the risks of the stunt?
Specifically under 702, Your Honor?
Right. So we just heard from Mr. Gogia that it was represented by Ms. Doig that the stunt coordinator had signed off on the stunt, right? And this says the exact opposite. Why can't he use it to rebut that?
Because, Your Honor, frankly, we're not sure if there are other opinions that were shared that perhaps did say that this would have been safe. Based off of that section that they're reading off of, they're saying that he actually looked at the numbers from this particular expert, thought that actually the numbers did work out. So they're using that last part to actually show that apparently they thought that it wasn't safe. It's an expert opinion that they're still offering.
Okay, I find that it's not an expert opinion. I find that it's being used factually to rebut the alleged statement by Ms. Doig. So I'm going to overrule the objection. You can proceed.
Yes, Your Honor. I'm reading lines 170 and 171. How did you respond? Answer. I said, no way. That's cutting it too close, especially when I'm not there. With that, we close our case in chief.
All right. Ms. Vanderslice, are you going to be putting on a case?
Yes, Your Honor. Now we'll be calling Ms. Cole Doig to the stand.
All right.
Can I proceed, John?
Yes.
Good afternoon. Can you please introduce yourself to the members of the jury?
Of course. Hi, my name is Cole Doyle.
What do you do for a living, Mr. Doyle?
I'm a filmmaker here in California. I write, film, produce. I actually founded my own company, Dragon Studios, back in 2006.
And before I ask you any other questions, I want to give you a chance to respond to the allegations brought against you in court today. Ma'am, is it true that you ignored safety protocols on June 21st?
Of course not. As a producer, it's my job to make sure that those stunts are safe. I went to our safety coordinator. I made sure that the stunt that Peter would be doing, that it would be safe. Of course I cared about safety.
Is it true that you were the one who decided to have him go up in the air and do that stunt for longer?
No, ma'am, that was Peter's call. I checked in with him about the plan. He agreed. It was his decision.
Ma'am, I want to take a step back. Can you tell us what exactly that stunt plan was?
Sure. Based on that film that we were working on in 2021, Peter was supposed to get on a motorcycle, ride off of the edge of a cliff, and then free fall for a set period of time before pulling his parachute and landing safely on the ground.
And how many times did you perform that stunt on set?
Well, we practiced it 6 times on June 20th of 2023, and then we filmed it again the following day on June 21st.
Now, I want to talk about whether or not Dragon Studios was careful in preparing for every time that stunt would be filmed. How did you prepare for that stunt to be filmed on camera?
Well, we actually paid for a training facility so that Peter could practice that stunt before we filmed it.
Objection, Your Honor, under Rule 404, may I be heard?
Yes.
Our contention in this case is very specific, that Ms. Goia failed to give Mr. Jones a signal on June 21st. For opposing counsel to use testimony about other safety measures to prove that it's more likely she would have made that call on June 21st is propensity evidence. You can't defend yourself against a claim that you didn't wear your seatbelt by saying, I spent so much money on my suspension. That's not how it works.
Response?
Yes, Your Honor. We understand their argument, but in this case, we're actually using this to rebut evidence they brought about motive. Their contention today is that this company cared so much about that scene that they were willing to, I guess, let their own actor die while shooting it. In this case, though, we're actually going to show that they spent a ton of money on this scene. They spent a ton of money on this movie. Their motive was actually the opposite, was to make sure that this movie would go into theaters.
Yeah, I'm gonna allow it for that purpose.
Yes, Your Honor.
And you were telling us about the preparation for the stunt. How much money did you spend roughly on the preparation for that stunt?
We spent over $1 million on that training facility that I was talking about, as well as the equipment that Peter would be using to film that stunt, and safety equipment as well. We wanted to make sure that Peter had the adequate experience before we filmed it for the movie.
And were you the only one on set trying to make sure this was safe?
No, we actually had a stunt coordinator who we worked with to make sure that that stunt was safe as well. Her name was Sky Stebbins.
And I want to move on to who was making the calls on set. And was there ever a conversation about Mr. Jones using a stunt double?
Yes, Peter elected not to use a stunt double.
Was there a conversation about whether to use CGI or special effects?
The minimum that we did was actually adding mountains at the edge of the cliff so that it would look like Peter was doing that stunt. Other than that, it was Peter's call.
Was it the production studio's decision not to use more special effects?
No, that was Peter's decision.
There's one more call I want to ask about, the one about June 21st. And I want to ask how that day actually went. Were you in the control room?
I was. It was myself and Peter's agent. We were in the control room together.
How did that stunt start?
Well, like the 6 takes that we had filmed the prior day, Peter got on that motorcycle and he rode off the cliff and he started to free fall.
And what happened after he started going into free fall?
Well, just like we had talked about in the plan the prior day, after 9 seconds had gone by, I used my walkie-talkie to signal to Peter. I told him to pull his parachute at 9 seconds. That was the plan.
Ma'am, have you been in trial all day today?
I have.
Did you hear Mr. Jones's agent take the stand?
I did, yes.
Did you hear him say that you didn't make that signal?
I heard him say that, yes.
Is that true?
Absolutely not. It was my job to make sure that Peter was safe. When that timer hit 9 seconds, I did exactly what we had cleared in the plan the previous day. I told Peter to pull. I told him over and over and over again he didn't pull. I don't know what happened.
Ma'am, what happened after you made that signal?
Well, after I gave the signal, after I told Peter to pull and he didn't, I kept shouting it, but he just kept falling. And by the time he pulled his parachute, it was too late.
And was there any reason you had to prioritize that scene over his safety?
Absolutely not. I care about the quality of my films, but first and foremost, I care about the team that I work with. I would never jeopardize Peter's safety just to get that movie in theaters.
Can you tell the members of the jury who Peter Jones is to you?
He was my coworker, but more than that, he was my friend. I would never do anything to put him in a position where he could be hurt.
Thank you for your time. No further questions at this time.
Cross-examination?
Yes, Your Honor. Before I get started, we plan to use a video exhibit. Is it all right if I just do a check of the technology to make sure everything's on right?
Go right ahead.
We had a computer die on us, so we're just getting things back set up.
All good.
In the interest of time, I might get started and then I'll check back in with you.
Okay.
Good afternoon, Ms. Goia.
Good afternoon.
You're a producer, right?
That's right.
So let's set this scene. On June 20th, 2023, you were in a control room, right?
That's right.
Now, at this point, just like in this room right now, there were a lot of people, weren't there?
Of course. We have several crew members that we work on in our movies. They were present on June 20th. That's right.
Not just several crew members, a dozen crew members, correct?
That's right. Yes.
That included a stunt coordinator, true?
Yes. We worked with Sky Stebbins to make sure that the stunt that Peter would be doing, that it was safe. That's right.
And on that day, when everyone was overseeing this stunt, you were able to pull it off successfully 6 times, true?
That's right. Every single time I gave the signal, Peter pulled his parachute, he landed safely on the ground.
Let's talk about what happened on June 21st. Because there were quite a few things different that day, weren't there?
You'd have to be specific, sir.
Let's get specific. Those dozen crew members you just told us about, they weren't there, were they?
Well, we had crew members stationed throughout the scene. Some were on the ground where Peter would be landing, some were in a helicopter to film, and then there were some crew members in the control room as well.
Ma'am, to be clear, when you say there were some crew members in the control room, there were actually no crew members other than you and Mr. Jones' talent agent in the control room, correct?
That's right. It was myself and Peter's agent.
You and Mr. Jones' agent.
Objection, Your Honor, at this time under Rule 404, may I be heard?
Yes.
Your Honor, at this time, opposing counsel, for his own logic on his previous objection, is using previous instances of other decisions they're claiming are careless to prove that in the instance they're claiming was careless, that signal in the air, will they be more likely to take that risk and not make the call?
So I don't think, what was your question going to be?
My question was going to be, you're not a stunt coordinator.
Okay, and okay. Obviously, we don't have an objection to that question, right?
No, Your Honor.
All right.
My objection is specifically to the answers he's eliciting from this witness right before that, specifically asking about the fact that the day of this stunt, that there weren't other people on the set, that there was less crew there.
Okay, and your response to that?
Yes, Your Honor. One of the facts we're proving is that Peter Jones died because he didn't receive the signal. The fact there were no other crew members in the room and he wasn't wearing an altimeter meant that when this defendant didn't do her job, there were no backups in place. Nobody else to make the call. It was just two untrained people in a control room.
Okay, I'm going to allow it for that purpose.
Yes, Your Honor.
Ma'am, to be clear, you're not a stunt coordinator, are you?
No, that's why we hired Sky Stebbins, so that we could work with her to make sure that that stunt that Peter was doing would be safe.
The person you hired to make sure that stunt would be safe, she wasn't there, was she?
Not on June 21st, no.
Then let's talk about why you were there on June 21st in the first place. Because we can agree, you got 6 takes on June 20th, correct?
That's right, yes.
Those takes weren't good enough for you, were they?
I wanted to have the scene be a little bit longer. That's why I went to Peter on the evening of June 20th, and we talked about that plan. He agreed to that.
You wanted a longer shot, right?
That's right,
A more
yes.
substantial shot, correct?
That's right.
So let's talk about whether you actually gave that signal. Because on direct examination, you claim that you sent Mr. Jones a signal, is that right?
That's right. Our plan was that at 9 seconds, I'd give Peter that signal to pull his parachute. That's what I did on June 21st.
Ma'am, you heard Mr. Goia testify, correct?
I did, yes.
He was with you in the control room, right?
He was.
He said you never gave that signal, true?
That's what he said. I'm not sure if he didn't hear me, but I gave that signal at 9 seconds. That was my responsibility, and that's what I did.
Man, Mr. Goia, he's not the plaintiff in this case, is he?
No, he's not.
But you are the defendant, correct?
That's right.
You stand to lose money, correct?
I know that that's a possibility, yes.
You stand to have your reputation take a hit, correct?
That's possible, yes.
Then let's talk about whether the video evidence matches your story. Mr. Donovan, are we good to go?
All set, Mr. Farnsworth.
Excellent.
I can just reposition myself.
Sure.
Now, you said on direct examination that you waited 9 seconds after Mr. Jones took off before you sent the signal, correct?
That's right. That's the plan that we had agreed on.
Okay. Mr. Donovan, could you play 9 seconds after that first jump? Man, that's a 16-second timestamp. That's 9 seconds, correct?
I believe so, yes.
This is the moment when you're claiming you yelled, pull, 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 deploy, 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 right?
That's right. That's what I did.
Now, the day before, you gave that same call, correct?
I did, yes.
Every time you did it the day before, Peter Jones pulled his parachute immediately, right?
Yes, that's right.
Objection, Your Honor, to character evidence, may I be heard?
Sure.
Opposing counsels using the instances on the day before to show that in those instances, Mr. Jones acted with safety. And they're using that to prove action and conformity therewith on the day of June 21st to show that actually he did the same thing on that day. He'd be more likely to act in conformity with that character trait.
Response?
Yes.
Your Honor, this evidence is already on the record. It came out during direct examination. Opposing counsel asked this witness about the 6 correct takes, and she testified that every time when she gave the signal, Mr. Jones pulled his cord.
You agree?
No, they're actually asking for this particular witness's interpretation of what happened as a person who was actually communicating with Mr. Jones in the air. We believe this testimony is different in that nature. They're having the director, who was actually part of the stunt, testify what he did.
Yeah, what interpretation is she being asked to give?
She was the one, we have it on a good faith basis, who was looking at the monitor, looking at the stunt as it was happening, and had more knowledge about when Mr. Jones actually pulled the parachute. We believe this is slightly different testimony, Your Honor, and they're using it this time for character evidence.
Okay, so on direct, you agree that on direct, the witness said that he practiced this stunt several times, and every time I made the call, he pulled it. Do you agree with that?
We don't have a court reporter. We take opposing counsel, I guess, at their word, but we believe that asking this producer who was actually working with Mr. Jones on the stunt and was a part of executing it, we do believe that's still different. And in this context, where they're asking about June 21st, it's character evidence.
What fact is he asking about that's different? And what fact is he attempting to elicit? What is he asking her to interpret that's different than what she said on direct?
We just believe that this witness has more personal knowledge than the previous witnesses, so the weight of that evidence is different in this case.
Okay.
And because it has a greater weight, in this case, it's character evidence and more likely to be taken as such by the members of the jury.
Okay, I'm gonna allow it, but to the extent that you think the argument crosses the line into propensity, in other words, safe before, must have been a safe person the following day, then you can re-raise your objection. I think we're close, but I don't think we're there yet. Okay?
Yes.
Yes, Your Honor. Ma'am, to be clear, on June 20th, when you gave the call, Mr. Jones pulled immediately every time, right?
That's right, yes.
Let's see what he does here. Mr. Donovan, could you play and pause the video at 20 seconds? Ma'am, right after you say you gave that signal, Mr. Jones doesn't reach for anything, does he?
Not that I can see. I'm not sure what happened. I gave him that signal.
He doesn't reach for his earbud,
Not an octa.
not for his reserve parachute.
Not that I can tell. No.
Doesn't even flinch, does he?
I don't believe so. No.
Ma'am, this frame Mr. Donovan paused on, you can actually see Mr. Jones' hands, can't you?
That's right.
You can see they're behind him, right?
Yes, that's right.
He's still not reaching for anything, true?
No, not that I can tell.
Then let's talk about why you might not have this. Ma'am, you've lied to actors before, haven't you?
That's right. Back in 2012, when I was working on a movie then, I did. I've learned a lot since then about filming stunts in movies. I'm a different person now.
You've lied to actors about the risks associated with this scene.
That's right. I did back in 2012.
Ma'am, you believe that real danger can produce great acting, correct?
I believe that's a possibility. Yes.
Thank you. No further questions.
Redirect?
No redirect, Your Honor.
All right. Do you have anything to read into, or are you resting?
The defense rests our case in chief, Your Honor. With Your Honor's permission, may the witness step down?
Yes. All right, so let's take 1 minute, and then we're going to get right into closing arguments, unless any of our jurors are desperate for a break. Great.
Your Honor, may I approach the jury box for who's at the top?
Yes. Okay. Are we ready to proceed?
With permission to just do the same and retrieve exhibits 36 and 26 through 29.
Why don't you just get them all? All right. Now are we ready to proceed?
Plaintiff is.
Great. Whenever you're ready.
That's how long Peter Jones could spend free falling safely. 9 seconds. When Mr. Jones was falling from 2,700 feet in the air, he spent those seconds waiting for a signal from Mr. But after 9 seconds pass, another second passes, another second passes, and still no signal. In those last moments, when every second counts, this defendant let time elapse without saying a word. He waited for a signal that never came. And that's why we're suing the defendant, Dragon Studios, for negligence. Now, the law that we talked about at the beginning of this trial boils down to a few very simple questions. You're going to see these questions when you go back to deliberate. And when I find the verdict form, I'll tell you. The first question that you're going to be asked to deliberate on is, did the plaintiff prove the defendant's negligence was a cause of Peter Jones' death? We showed you that you can answer yes. Let's talk about how we did. First, we proved that the defendant promised Mr. Jones that she'd signal after 9 seconds had passed, and that signal would be when he pulled his parachute. This fact actually isn't in contention today. Ms. Goia admitted the night before the last stunt, she said it. At 9 seconds, yes, that was the plan. So that brings us to fact 2, that the defendant never actually sent that signal. And this fact is really the heart of the disagreement in this case. Was the signal sent or was it not? And I'm going to give you 3 good reasons why you know that signal was never sent. The first is that the defendant has a reason to lie. You heard from our witness, Mr. Goia, who took the stand and told you that when he was in that control room, the defendant never sent a signal. Now, the defendant's story tells otherwise, but think about what she stands to lose. Compare our witness with their witness. Our witness isn't the plaintiff. He doesn't stand to gain a single dollar, dime, cent of money from this lawsuit. The defendant, though, the defendant does. Her reputation, her money is on the line. She has a reason to lie. That brings us to the second reason. You know that signal was never sent. The defendant's lied before. She testified on the stand that she's lied to her actors in order to get real danger out of them. That's a reason she has for not sending the signal, but it's also a reason she has to lie. And it's not only that. Because Mr. Goia, when he took this stand, he actually told you about a conversation that Ms. Goia had with Mr. Jones the night before the stunt, where she said, yeah, my stunt coordinator, he's okayed this, he's greenlit. But when we read that stunt coordinator's deposition onto the record, you heard the stunt coordinator said, no way, Jose, that's not okay. She's lied not only to her actors, but to Mr. Jones about the very stunt that killed him. So let's talk about the third reason. You know that signal was never sent, the video evidence. We showed you the video of Mr. Jones' free fall. We showed you the exact moment this defendant claims she called him up and said, pull, pull, pull. But you didn't see Mr. Jones flinch, reach for his parachute, or reach for his earbud. He keeps falling. Don't you think if that signal was really sent, actually sent, he would have done anything? Of course he would have. Opposing counsel has talked throughout this entire trial about the calls Mr. Jones made. But what gets me is that the reason Mr. Jones died is that he was waiting for a call the defendant never made. That's why you can write in yes, for did the plaintiff's negligence cause Mr. Jones' death. Now, the defense has also brought an affirmative defense of comparative negligence, which means did Peter Jones not exercise ordinary care towards himself, and was that the real reason he died? But you know the answer to that question is no. Because the reason Peter Jones died was because he expected the defendant to do something they didn't do. This case is about causation, the why. And opposing counsel has talked a lot about motive, reasons Peter Jones had to want to do a big stunt. And that might be true. But it also goes for the producer on set. Because she was the one who stood to gain from the movie. And if Peter Jones spent a lot of times falling during that scene, that would have made her wrong. She was the one behind them. She was the one Peter Jones was waiting for and she was the one who caused his death. When you go back to deliberate, we're going to ask you to write in no for question 2. Folks, this case is about a signal the defendant never sent. And that's why when you go back to deliberate, you're going to be able to send the defendant a signal right back. That what they did was wrong. That actors deserve more than a director who's willing to lie to them about the risks of a stunt and push them to their death. He waited for a signal that never came. And that's why we ask you to find the defendant liable. Thank you.
All right. Whenever you're ready.
Yes, Your Honor. May it please the court, Mr. Farnsworth, members of the jury. It was his life on the line. He made the call. Back in 2023, Peter Jones was at his peak. He was a household name. He wasn't just a part of a multi-billion-dollar movie franchise. He was the multi-billion-dollar movie franchise. Every movie was better than the last. Every stunt was bolder than the first. But the problem with that is, members of the jury, what is bolder than hanging off a mountain? What could be bigger than rappelling down the world's tallest mountain? What could impress his audience more than hanging off the side of a moving airplane? Well, you and I might not have the vision to make that answer, but well, Mr. Jones sure did. See, he made a plan. He made a plan to get on a motorcycle, to ride it off the mountain, to free fall down the side of that mountain. And you see, members of the jury, that's what happened. He decided not to use a stunt. He decided not to use a safety harness. He decided he didn't need special effects. He decided this would be the real deal. It would be his life on the line. And when the producer pulls him to the side and says that he needs that scene, she needs that scene to be a little bit longer, well, Mr. Jones makes the call. Mr. Jones says, no editing needed. I'll take care of it. I'll do the stunt again. I'll hold on for longer. I'll pull my parachute later. The reason he was up there in the first place on June 21st wasn't the production company's call. It was Mr. Jones's call to make. And when the plaintiff takes on a burden today, well, they took on a burden to prove that it was actually the production company that was making these careless decisions, that their decisions are what caused Mr. Jones's harm. Now, Mr. Farnsworth gave you 3 good reasons. I'm going to give you some more. I'm going to give you 2 reasons why they weren't able to meet that burden today. The first reason is because they weren't careful. And the second reason is that Mr. Jones made the calls. Let's take those one by one, starting with the fact that they weren't careful. They tried to paint you this picture of Miss Goldoi, this producer who was profit hungry, who was money driven. But is that what the evidence showed you today? Because when she took this stand, she told you that actually they shelled out millions of dollars to make sure that actually this would be safe. They hired the best stunt coordinator in the business to make sure that the numbers checked out. That kind of makes sense, doesn't it? Her whole story today was that they had this motive, that they cared about the scene, they wanted to make the money. Sir, don't you think that if that was true, well, they wouldn't be so careless as to kill off their biggest asset? They certainly haven't made more money since their lead actor died, right? And if Miss Doyle, the producer, really cared just about the box office, well, don't you think that she'd at least want there to be a movie for people to buy tickets for? So they did all they could. All they could to control what was in their control, the crew, the stunt, the signal. But the one thing they couldn't control was Mr. Jones. And that brings us to our second point, which is that Mr. Jones, well, he made the calls. And you don't need to take my word for it, members of the jury. We asked both witnesses on both sides of the case, well, whose idea was it to do that stunt? Who actually decided to go up into the air for the 7th time, to do it for longer? And that was Mr. Jones. And that's why we took on what's called an affirmative defense today. No one's telling me that this isn't a tragedy. No one can deny that fact. I grew up watching Mr. Jones's movies myself. The thing is, members of the jury, the thing is, you have to consider all emotions aside, whether Mr. Jones's decisions were careful, whether Mr. Jones's decisions could have caused his death. So let's walk through. Let's walk through exactly how we met that burn. Well, you see, Mr. Jones was the one who made the decisions. As much as Mr. Farnsworth wants you to believe that it all comes down to one take, one moment, one signal, it doesn't, members of the jury. It's about decision after decision after decision that Mr. Jones took. Mr. Jones took that put him in that situation to begin with. No stunt double, no special effects, no CGI, no safety harness, no landing pad to catch him when he fell. Those were all Mr. Jones's calls to make. See, members of the jury, that matters. That matters because what it comes down to is really who's more at fault. And you only need to even consider our burden if you think that the plaintiff has met theirs. And like Mr. Farnsworth said, well, it's a bit of a he said, she said. But let's say you take what they told you at face value. Maybe the company didn't make the signal in time, even if that's true. Who is more at fault? The company who made the signal too late, or the actor who actually let his life hang in the balance, mattering by just a few seconds? The actor who chose to do that stunt, the actor who came up with that stunt, the actor whose life was on the line and who was calling the shots on set. Members of the jury, you go back into that deliberation room, I trust that you're going to make the right call. At the end of the day, Mr. Jones was just a person. And people make mistakes. Sometimes even with their life on the line, they don't make the right call. The Fine Dragon Studios, not liable. Thank you.
Rebuttal?
Yes, Your Honor. Do you know what all of those photos have in common? They're all scripted. The stunt in this case was scripted as well. The defendant made a promise that after 9 seconds, that was their mark, their cue in this scene, that they'd give a signal. Opposing counsel wants to say Peter Jones was responsible for his own death, when the defendant was the one responsible for giving him the sign to pull his parachute. They broke that promise. And that's why you should find them liable. Thank you.
Let's give him a round of applause. I'm going to ask our scoring judges to fill out their ballots. We're running a little behind. So I'm going to ask our judges to each give their favorite moment from trial. So one comment per judge. That way we can get to the next round, to the announcement. So I'll let you know when they hold the ballots.